Welcome, everyone, and thank you all for attending our meeting of the Committee on Limited English Proficiency. We have, I believe, everyone present except Attorney Michelle Fica, who often joins us, but we're not certain if she's able to join us today, and we did not want to hold up starting the meeting longer. So we will get started. Again, I just want to thank everyone for attending. I also want to thank Heather Collins, who not only is an active member, but also our staff member who puts these meetings together. And I cannot stress how much we rely on her for all things in terms of administratively, but also substantively, and her history and knowledge of access to justice in general. So thank you, Heather. And
Thank you.
Thank you. And I also want to thank Richard Lafredo and Alejandra Donath, my co-chair. And she always lets me start, but really the kudos goes to them. They really do 100% of the work, and I want to thank them. I do want to thank them specifically. I know I did a little piece of it. They did the bulk of the work, not only all throughout the year, but answering the survey. And Connecticut ranked, I believe, #2 in the country, next only to DC in terms of language services in a nationwide study done out of Fordham Law School. And Connecticut ranked #2 in the country. And I think that's really impressive. And that goes to the work of Richard, Alejandra, Heather, this committee, and our staff, our incredible court operations staff, judges, everyone. And Brandon Pelagano is no exception. Our legal team, Viviana, and just everyone on this committee, I want to thank you for your work. I'm really proud, and kudos to Richard and Alejandra for doing that. So thank you so much. The first order of business before I turn it over to Richard, who will lead the meeting, is the approval of the minutes of our last meeting, December 2021. If you had a chance to, hopefully everyone, to review the minutes, let me ask first whether there's anyone who will do a motion to approve the minutes. Brandon's motion to approve. I see his hand up. Any seconds?
I'll second.
Viviana Livesay is a second. Any discussion? Seeing no discussion, let me ask all those who approve the minutes if you would raise either your virtual hand or your actual hand. Everyone has approved the minutes. I should, any abstentions? Any nays? Any rejections? Seeing none, the minutes are approved. I know that we have quite an active agenda. I know you, our members received some materials, both from the legal department and from Richard and Allie about training and our grievance and complaint process. So I'm going to turn it over to Richard to the first item on the second item on the agenda, being the LEP refresher training.
Thank you very much, Your Honor. And obviously, we can't do any of our work without you. So thank you very much
Yes.
for all your support and guidance through all of this process. LEP refresher training. So I know we spoke about this over the last handful of meetings about creating an online refresher training for all branch employees. Allie and I met with the Employee Education and Development Unit yesterday. We are pretty much have finalized the script. There's just kind of some grammatical things we need to go through one last time. I know everybody here has already seen it. So once we finalize that, then it will be recorded. Chris Quate, who's one of our interpreters, will be the voice for that. Memory serves, he is also the voice of the last training that we've done. He's got experience doing that. So once Chris records it, which should be done in the not too distant future, it then takes a couple of weeks for the employee education and development units to do the closed captioning for it. I guess there's two different options with the new articulate software, whether it's closed captioning or the notes section. In looking at it yesterday, the closed captioning works a lot better because the notes section, you have to physically actually scroll down as the words are going, where closed captioning will come up as the words are spoken. So we figured we'll take the extra time for them to do that, so it'll work better, I think, in the long term for that. So I think that so we are moving along with that. Once we have all of that done, we will share a link with everybody here so we can see it before it goes live. The one outstanding question that we do have for that is the time frame, on the requirement time frame. I know we talked about this at the last meeting as well. Best practices and the Justice Index recommend required training once every 3 years. I know we've talked amongst ourselves in this group about a couple of different options, whether it's once every 1, 2, or 3 years, setting up a time and allowing supervisors to do it less, or based on job classification as well. I spoke with Janice Calvi, who is the deputy director over employee education, about kind of the logistics with LMS and her thoughts on the different options. Her view is that it would be best to and logistically easiest to have a set time frame as opposed to different time frames based on job class. So which makes sense to me. So I'm okay with that if everybody else is. And then it would really just come down to recommending what that time frame is, whether it's the 1, 2, or 3 years. And with everything, at least in my view, is this: a supervisor always has the discretion of requiring their staff to take it in a earlier time if they want to. So with that, I will open it up to folks' thoughts on everything I just said.
So I think it would be great, Rich and Ally, if we heard from our committee members first. I have an opinion, but I will keep it to myself, because I know what happens if I start speaking and everyone thinks that they might feel pressured to defer. So I'm interested in hearing what all of you think as well. Brandon.
So I, of course, am just one voice. I don't speak on behalf of the courts. That would be the director, of course. But I did reach out to 2 of my colleagues in different districts, just inquiring. I didn't explain what exactly we were doing. I just said, gee, what do you think the timeline should be for something like the LEP course? Each of them actually had said it would be great to have a refresher course once a year. And, I look at that personally, and I think to myself, that's a great schedule to get on once a year. This is something we don't want to mistake if and when the time comes that we actually need to use these services or know about the services. We have such turnaround, I think, in our offices at this point, from the TACs, the tax and temps that are coming in, to even the permanent employees with so many job opportunities bouncing from one location to another. So personally, I think it would be a great idea to at least offer it once a year. I would not be heartbroken if you came out and said, well, the policy will be every other year, because to your point, Rich, I still have the flexibility to say to my team, we are still going to do it once a year. So let's stick to that routine. So I just wanted to throw that out.
Thanks, Brandon.
You bet.
Troy. Yeah. I'll let you call, Richard.
Sure. Troy? You're on mute, Troy.
You're muted.
Thank you, thank you. So I'm in agreement with Brandon. I think once a year is where I would have my preference. I would be okay if it was every other year because supervisors could have folks take it more frequently, but I wouldn't want to rely on supervisors have to remember to have their staff take it more frequently, or some of them may feel the pressure of actually having to require that of individuals, some individuals doing it, others not. I would lead towards once a year. Remind me again the length of the length that we anticipate this is going to be.
My hope is it's only going to be 30 to 40 minutes. It's short.
Yeah, now I'm even more convinced that once a year is reasonable. Plus, you know, when given this information once, after a couple of weeks, I often forget what the requirements were, and so waiting to 2-year mark more likely means that I forgot totally. And so the refresher once a year is a much better idea. It also shows our commitment to wanting our staff to really understand what is the process for working with individuals who are LEP.
Very good. Thank you. Viv?
Yeah, I agree with the 1-year requirement. As an attorney for judicial, I'm required to take state ethics online training once a year, and we're required to do that by the 31st of December every year. So I have no problems doing that, and I think it just makes sense to have it due by the end of the year. Make it simple for everybody.
Very good. Thanks.
Yes, and if I may, based on our operations and the needs, and it will just simplify our function on the daily basis when staff is well aware and knowledgeable of how to work with interpreters, how to request interpreters, and the whole legal commitment to it. It will just make the whole operation so much easier.
Okay.
I wanted to do a shout out to Brittany Kaplan, who I neglected to mention, who just told us her perspective. She is fulfilling 2 functions today, not only as an active member of our committee, but she's also ensuring that our meeting is public and on YouTube. And for that as well, I thank you, Brittany, for participating today. Did we hear now? I know that Michelle, Attorney Fico, is not with us. She's today. She's a legal aid attorney. She works a lot, I think, out of the Waterbury area. But I cannot speak for her, but based on my impressions of statements she's made during our prior meetings and the need to ensure that everyone is on the same page about what our services are and how they can be obtained, I can't imagine that she would not support a yearly training either. But again, I cannot speak for her, but just you all remember some of the, statements she's made in the past. So I would think she would support that as well. I completely agree with the very well-reasoned, articulate positions all of you took, and I would suggest once a year as well.
Okay. Clearly, that will be the proposal to Judge Carroll. Perfect. So that's great. So what I will do is actually kind of bleeding into the next topic is the LEP committee report, which I sent to everybody. That's our yearly report for the work that we did last year in 2021. I have incorporated everybody's comments into the version that I sent out, I believe it was last week. So the only thing that needs to be amended into that is I'll add the 1-year recommendation for the training. And then unless anybody has any disagreements, I will forward it to Judge Carroll for his approval.
Sounds good.
Hearing none, Very good. So what I will do is add the yearly time frame. I will send it to Judge Carroll for his approval. Then upon his approval, it'll get posted on the branch's website in English, and then we will have it translated into Spanish, Polish, and Portuguese, and have it the report posted in those languages as well.
Wonderful. That sounds great. And I want to thank you, Richard, for doing the lion's share of this work, and Ally for getting the draft that the three of us worked on, and then for sending it to all of you, and you quickly gave us some great input. So thank you for that as well. I do want to ask Richard, in terms of translation of the report, once the report is approved, I just wanted to follow up. Last meeting, we talked about translation of some of the instructional forms on
Yes.
how to access remote
Hearings.
hearings. And
Yes.
I just want to confirm that I heard and had checked that it was done. And I just want to confirm that that has been done into at least Spanish, and then preferably the other two additional languages.
Yes, so yes, Your Honor, I was going to get to that in the.
Oh.
I thought we had an other business category, but I guess not.
No, we didn't. That's why I asked now, because we were on
I
translation.
we had that in the agenda, but
That
no.
got deleted, I'm sorry.
So what happened was, so when the initial document came out back in early, back in 2020 with the onset of the pandemic, the English version came out, and that version actually was translated into Spanish, Portuguese, and Polish, and was posted online. They had since updated the full document, the main 45-page document. So these translated documents were pulled offline because it conflicted with the revised version. The revised version is just about finalized for translation and will be posted online. There are also the quick cards. I spoke with Alex Gillette earlier today. She's trying to figure out whether or not the quick cards are going to be revised in the not too distant future. If they are not going to be revised, we will have that version translated into Spanish, Portuguese, and Polish. If they are going to be revised in the short term, we'll hold off on the translations until the revision is done, and get the quick cards translated and posted online as well.
That's great. Thank you so much. Thank you for the update, and thank you for our legal team as well.
Yeah, no, it's Ally could speak better than I can, but I'm quite sure it is not the easiest document in the world to translate.
I can only imagine. It's full of technological terms, I'm sure. I've seen it. I know it is, yes.
Yep. Up next, the grievance procedures. So we've been kind of talking about this kind of on and off for maybe about the past year, about a grievance process, which we do not have any formal process in place currently. We have an informal process. If anyone was to complain about the either the lack of or quality of language access services that an individual receives. There's also one of the best practices recommendations from the Justice Index that we were honestly lacking in, because we don't have that. So Viv and the folks over at Legal Services, I believe Brianna Noble over at Legal Services, along with Viv, did a lot of research from other states on their grievance processes, and came up with a memo and a draft process for us that was circulated last week. But I will turn it over to Viv, who will kind of summarize the memo from Legal Services and the proposal.
Yes, I'm just going to highlight some of the items in the memo. as Rich said, our new research attorney was asked to look into how other states handle LEP complaints. And she focused on our neighboring states, New York, Massachusetts, Rhode Island. She looked at some New England states, Vermont, New Hampshire, and Maine. And she also focused her attention on 3 states that have large LEP populations, California, Texas, and Florida. And what she discovered is that most states have a process that's initiated by a form that the courts have developed. It's either electronic or in paper format. The form solicits certain information, such as the complainant's name, contact information, a description of the incident, the persons who were involved, the location and the date, and witnesses as well. At least one jurisdiction in New York allows the individual to upload documents, attachments. The form is available, and the instructions, the policy is available in multiple languages in many of the jurisdictions. California, for example, has it in 10 different languages. And on page 2 of the memo, you'll see that the complaint review process varies among the states. In Massachusetts, for example, the Office of Language Assistance reviews complaints. In Rhode Island, the state court administrator or his or her designee. And for example, in Florida, the Court Interpreter Certification Board reviews complaints. Also, we discovered that in Rhode Island, the LEP complaint process was established by a Supreme Court executive decision, or order rather. So we took all this information and I drafted a proposed grievance policy for Connecticut. It's a starting point. We can modify it. I've inserted, deadlines and dates that can be shortened or lengthened. But I'll start with my first recommendation, and that's designating somebody from the interpreter's office to serve as a language access officer. And this individual should be familiar with LEP legal requirements and would be responsible for reviewing all the complaints. The complaints would be sent to the access officer either online or in paper or faxed. We could provide a complaint form, but it wouldn't be a requirement. It would just be something that would be useful for the complainant to use. It would need to be filed, and this is where we can play around with timeframes. I recommend 30 calendar days for the submission of the complaint. The language access officer would then initiate an investigation and would have 15 calendar days to contact the complainant, talk about the allegations, gather information, and discuss possible resolutions. And of course, legal services would also be available to consult this officer for advice. The officer would issue a written report no later than 60 calendar days from the date they received the complaint. And then the complaint would be forwarded to the complainant no later than 5 business days after it's issued. And the complainant would be informed of other remedies available to him or her from the DOJ, for example. And then I recommended a retention period of 3 years for complaints, but we could play around with that. We could add more time or less. So that's just, in essence, what I'm recommending.
No, thank you very much, Viv, and to Brianna as well. I think it's great the work that you've done with this. I will note I did send this to HR because I was curious before we get too far down the line about union issues regarding this, and they were okay. They're okay with the concept and what was proposed. They did say that I may have to bargain with them on impact issues if there's disciplinary action as a result of this, but they're not preventing us from moving forward.
Okay.
So folks have thoughts on the memo and what they've outlined. Brandon.
So I think it's something that's a very important tool that we should have in place so that we can at least gauge how things are going and give folks an opportunity to let us know better. I do have a few comments about it, but I wrote them up and I thought maybe rather than discuss them at the meeting, if I just forward this maybe over to Viv or to the group. But one in particular, for example, on the first page, item 3, when it says the investigation shall be prompt and informal, but thorough and afford all interested persons. To your point, Rich, my immediate reaction went to, what about union employees? So prompt and informal, it may not be informal because the opening paragraph of this indicates 3 different ways or 3 different reasons why a person may want to file a complaint. One being you have experienced discrimination or harassment by judicial staff based on your limited English proficiency. So for example, if someone in my office unfortunately behaved this way, I would not necessarily want it to be informal. I would want it most likely to be formal. Yeah. So there are comments along those lines that I think maybe if I just send it off to the group just to see what I have.
Yeah, no, that would be great.
Perfect.
Perfect. Yeah, thank you.
Absolutely. But I think it's a great idea and I think it's well needed, much needed.
Thanks, Brandon. Troy?
Yeah, thanks, Rich. Yeah, I'm glad you mentioned that, Brandon. As you were talking about it, it made sense. I was like, ooh, I don't know if I'd want it to be informal. So I'm looking forward to seeing what you're going to send on over. I think that'll be great. I think it's a nice job on this. So, kudos. And I think it is I think it'll be worthwhile. I did, and I heard what you said, Viviana, and that is item number 2 in the grievance procedure. The complaint should be filed within 30 calendar days. Can you tell me your thoughts around 30 calendar days? I just want to get a little bit more perspective.
I picked a number that I thought was fair in order to allow a person who doesn't speak English has obstacles to overcome, and it may be difficult for them to figure out the grievance process. So I didn't want to give them, I think ADA gives them 10 days. And I thought that was far too short and maybe somewhere in between. But I inserted this number just as a starting point. I'm not fixed on 30 days. But I did think that people with LEP need a little extra more time than the ADA folks, for example.
All right, thank you. I'm with you. I think you need a little bit more time. I just don't know if 30 days is going to be enough time for individuals. And unfortunately, I'm not familiar how often people actually have to come back to court, because it might be by the time they come back to the second visit that they may think they need to do something. I don't know if they come back on average every 30 days or 45 days or so forth. So I don't have that information. The first thing that I thought of was 90 days. So give them 3 months, because it might take that long for someone actually to muster up the gumption to say, I think I'm going to file the complaint, or I've had enough time to get some information. But that's not wedded to any data or any experience I have.
No.
So, similar to you, I just tossed out a little bit more time.
Yeah.
Okay. No, well taken. Thank you, Troy.
Thanks.
Justice Khan.
Thank you. First, again, I just want to say thank you so much, Attorney Livesay, for the work that you did and your staff. And I particularly like that you picked not only our sister states, but also states that provide a lot of LEP services. So that was a really good balance. And I think states that, like us, are on the forefront of LEP services. So that's very helpful to have a summary of what they do. I too looked at the 30-day and had the same thought Troy had, but I also had an additional thought, which is if we wait too long, then we lose, the information becomes dated when it comes to the investigation. So we have two sort of counterbalancing things going on. On the one hand, we have making sure LEP individuals have enough time to file a complaint. It is, I think Troy's right, typically people come once a month if their case is active or ongoing. If it's a staff member, they may or may not encounter the same person, but if it's, for example, a contract interpreter, that may be enough time. In fact, we may want to know sooner so that if there is an issue, we get a different provider. So there are these competing interests. So as we think about the time, I don't want the information to get so dated that someone like Brandon or Troy, in supervision of their staff, or Alejandra and Richard, they can't get to the information timely, or it's been lost, memories, forgotten. So I think we should, whether we settle on 30, a little bit more or a little bit less. I forgot about the ADA being 10 days, which is interesting. I'd forgotten about that, but that tripling that kind of makes sense to me at a minimum for LEP. Going much further down the line, people start to forget, you know, the interaction, and then we may lose the ability to fully investigate it. So that would be the only thing to keep in mind that I would ask as we settle on the time.
No, very good. Britt, any thoughts? Very good, thank you. So I think what we'll do next with this is we'll look at what Brandon sends us and can continue delving into this a little bit further and have a new draft for our next meeting where we can just keep moving along the process.
Mhm.
I think that sounds great, and I know everyone on this committee is very responsive. So to the extent we can give Viviana what she needs, and all of us together work on discussing these issues, and the point Troy raised, which is also, you know, excellent. If we can get it towards a final draft, then maybe we could approve it. The goal, I hope, would be that we would approve it at the next meeting, because we meet about quarterly, right, every 3 months.
Yeah.
So I think that if it's all right with everyone, that should be our goal, because I actually think the complaint procedure process that you put together, Viviana, is excellent. So I think these details are critical and we'll work on them, but I think it would be great if we could try to get it approved. So that would be my request, if you all agree.
Absolutely, that would be ideal
I
if we
agree.
could do that, and then you know, if we could finalize, if we meet next in June, finalize it in June, and then we could start the process of rolling that out. Would be terrific. Next up on the agenda is entitled memo. So what my thought with this is doing another memo to judges. We did one in 2015. We did one in 2018. I know at our last meeting we talked about training of judges, and we talked about CJI, and logistically CJI didn't work. We didn't get the request in time to be put on the agenda for CJI. We talked about a couple of different options with training judges, which we're still working on and going to do a kind of a combination of either both doing an online course for them and also doing an in-person kind of either remote / in-person roadshow with Justice Connally and myself as well. But you know, one of the things about getting stuff to the judges is we're beginning to get at a critical point with our lack of interpreters. And it's requiring us to be requiring Allie to be a lot more creative in trying to schedule interpreters to cover everything that's needed. You know, between the lack of staff both that we have, in addition to our vendors not having bodies as well to provide us, you know, we're kind of in a bind a lot of days. So the thought with the memo is trying to at least getting something out to them before we're able to go out and do any sort of training, because that's going to take time to actually do that piece. But a memo, hopefully from Judge Carroll, hitting on the main issues, which will kind of be expanded on in a training about the need for remote services, the need for flexibility with scheduling, the need, you know, not to cancel requests because you can't get an in-person. What else? Not going forward without an interpreter. Do not interpret yourself. Kind of all of those reminder topics kind of a concise, in my mind anyways, no more than 2 pages long, that goes from Judge Carroll to all of the judges, kind of just hitting all the points to at least hopefully open up some eyes on the difficulty that we're having right now with trying to provide the services that we need to provide with the lack of physical interpreters that we have.
I want to, I completely agree with a memo. I don't think it's going to fix it all, but I do think a memo coming from Judge Carroll will certainly lay the groundwork for when we do our individual meetings. And I want to point out that the idea of the individual meetings is first targeting areas perhaps where we've had more issues, and including the chief clerks and deputy chief clerks in each of those jurisdictions. So we're talking meeting with the judges and the chief clerks and deputy chief clerks, because sometimes it's also a lack of communication. So sometimes judges will go along with something thinking that an interpreter has not been contracted and paid for. We're relying more and more, as Richard said, on contract interpreters, because whether it's due to the pandemic or other factors, we've always had attrition, and now the vendors are having attrition. So, and getting judges to understand their courtroom is not the only courtroom necessarily at any given time or day where an interpreter is needed. And so working together in good communication within each courthouse between judges and court staff is critical. So that's the goal of these individual meetings, to make sure everybody's on the same page. There have been instances, many, where the branch is paying upwards of $500 for an interpreter that's consistently canceled. Meanwhile, the branch is still expanding those fees. And the other thing is making sure that when we are using remote interpreters, that doesn't mean they get to sit in a room waiting for the matter to be called when they could be interpreting other matters remotely. So there are a lot of efficiencies that we can accomplish with effective communication. And so that's the goal of this. I would add, Richard, to ask Judge Carroll, and I'm curious what Brandon and Troy, I know your role is supervisor director at CSSD, but I know Brandon is a great representative of court ops. Does it make sense? To me, it would make sense to have it sent to the chief clerks so that they can go over those things that the judges are receiving, the messages that the judges are receiving, and reinforce that with their staff. They're the clerks that are going into the courtrooms day in and day out with the judges, who may say, oh, judge, before we postpone that matter, can I just email ITS, or let me just check that we don't have an interpreter on the remote system or in the courtroom equipped with remote interpreting for that matter. So I think for both to get the message might be really important. But I'm curious if Brandon thinks that would be useful, or Troy.
Absolutely. I think it's paramount to making us getting it right. If we hear the same message, then there's no worry of it being translated, no pun intended, differently. So I think it is extremely important. If we have the same material or we're at the same meetings, then yes, it's more of a team approach, where when we hit one of these roadblocks, we could very easily turn to the judge and say, remember the meeting when, fill in the blank. So it's not something that we know, but the judges haven't heard, or the judge, vice versa. So I think that's a very important point, Your Honor, and it would make our jobs a lot easier, both from the judge's aspect and the clerks, in getting it right.
No, that's a good point. I did not think of that. I always think of sending stuff just to the judges, but if it can be sent to them both, I will definitely pitch that. I think that's a very good idea.
Yeah, I like that idea as well. I haven't been in the courts in the field in a little while, but every prompt that can be given a judge who has so much to have to remember on any given day, would be extremely helpful. And I think the clerks might be more mindful of that initially than some judges. And so if that prompt can be given to the court at that time, I think that'd be great.
Okay. Very good.
Yeah, and I think in 2008, we did 2 memos, one for the judges and another one for general judicial branch staff. So maybe we can just the judges and the clerks this time.
And I would ask that the clerks discuss it with their staff so that it comes from, you know, the level of Brandon to his staff and other chief clerks. I think it's important, especially the clerks that are going into the courtroom where they're sensing the pressure of postponing something or canceling something because they think erroneously there is no interpreter on the way or available in another method or format. Viviana had her hand up, so I'll.
Yeah, I have a question regarding training. Do you offer LEP training to new judges? I know that we have a group of 22 new judges that are coming soon. So I just wondered if they receive LEP training.
Yeah, so all new judges get, as part of pre-bench, there is training. I know historically it was Chief Justice Robinson and Justice Khan. With the last group, it was Allie and myself. I'm not sure how it's going to be with this coming up group of 22. But yes, they do receive LEP training before they go on the bench.
Okay, good.
And when we did the LEP training, when we did, Chief Justice Robinson and I did it, Allie and Richard would often attend.
Yes.
As well. So it was a group effort, and we use the same materials when we do the training. So I know that the last class received, and the training materials come from Allie and Richard's expertise. But you know, they definitely, it's a pretty long training too, as at least when we gave it, it was 3 hours, at least a full half day, not a full day, but a complete half day. And then they received some additional training later on in their judge school. There was more on cultural competency, implicit bias as well.
Yes. Brandon.
So just one suggestion when that time does come, rather than perhaps sending an email out from you, Rich or Allie, to all the chief clerks and deputies, maybe a good idea would be to reach out to Krista and ask if you could present it at one of the chief clerks meetings. Then you have a captive audience. They're going to hear the same message and it's going to be drilled in. You need to do this. You know, I personally have meetings after the chief clerk meetings with the deputies to share the information that had previously just come out. So that might be a great resource for you guys reaching out to her.
That's great. Yes.
No, good idea, Brandon. Great. Yeah, no, we're just trying to hit every avenue to try to, you know, it's a lot of it comes really because it does come down to communication and everybody being on the same page and knowing the limitations and what can and can't be done. So hopefully this will go a ways towards getting to that point. I agree with Justice Khan. The memo is not going to solve the issue, but hopefully with the memo, with the follow-up training, and whatever steps we need to do afterwards will get us further along in that process.
Mm-hmm.
Great, thanks. So I will add that to my lists to present to Judge Carroll. And let's see. I know there's not an other business item on the agenda. We neglected that, but let's do any other business from anybody.
I had the question about just following up to make sure the forms for the shorter version of the forms
Absolutely.
for the virtual hearings were done, and I knew they were, but I just wanted at our public meeting to assure folks that it was done. Those were my issues, and of course discussing that you and I that that I had met with the chief court administrator and deputy chief court administrator, and one of the suggestions and recommendations that was approved is that we have these meetings, Richard, Alejandra, and I, going around to various jurisdictions. Brandon, yours may be one of the last we go to because we're, preaching to the choir.
Very smooth sailing.
Yes. But that is the goal, and we'll be able to report, hopefully at our next committee meeting that we've done some of those. I know that Rich and Allie staff are talking to Courtney Black, my legal executive assistant, and she has access to my schedule. So she's plugging in whatever dates we have. So I thank you for doing that, both of you. I don't have other business, but maybe others do. Oh, Heather has her hand up.
Sorry, I know I'm not a member, but Rich,
No.
I wanted to just tell the committee because I'm support staff to the ADA Advisory Board, and that's primarily what I do here. And so Rich and I talked earlier, our board just submitted their annual report to the Chief Justice last week. And one of the requests that was approved by the board was to ask for the translation of the how to request an ADA accommodation into Spanish, Portuguese, and Polish. So we've made that request, and you all made our report, and we appreciate that because, people with I feel like we're both sort of serving marginalized communities. And so there's always going to be the interplay. People with disabilities do speak other languages. So I think this is going to be extremely helpful. So I can't speak on behalf of the ADA centralized office, but thank you. Just had to say it. I wanted to get it on the record. We appreciate it.
Thank you, Heather.
Thank you, Heather. And by the way, Heather, you're a critical member of this committee and this team. So you're a full member as far as I'm concerned, and a very committed member. And actually, Heather's comment makes me think of one additional item. I believe I mentioned it at the last meeting, but if to the extent I did not, we did have an Access to Justice Commission meeting. I chair Access to Justice. We meet every 3 months, and we did receive a report from the Access to Justice Committee Libraries Work Group. And they were very grateful for the translation, not only of instructional of videos for patrons, but also making the materials on how to access interpreters and other materials available to them in their kiosks. There was a bit of a pause because libraries were closed during the pandemic, but now that they're reopening, there's an effort to have kiosks or little legal centers within each library that's similar to our court service center, and the librarians are receiving training on how they can best direct patrons. The idea being that most people don't even realize they have a legal problem and they'll go to their local library. And so if they are trained to give people not legal advice, of course, they're not lawyers, but to direct them to appropriate services, and that would include LEP services. So they were very grateful for the work, Allie, that your unit division and Richard as director did for translating their materials and giving them those forms. So thank you for that.
Oh, perfect. Thank you, Judge.
Very good. I guess the last agenda item is next meeting. So like I said earlier, we'll probably try to schedule something in June once the legislative session is over and behind us. So sometime in June we'll do that, and so Heather will circulate dates for availability as we get closer to that. And unless anybody has anything else, I think we can move to adjourn.
Have a nice afternoon, everyone.
Brandon moved to adjourn. I saw Alejandra second that, and I thank you, everyone. Thank you, Richard, Allie. Thank you, everyone, for attending and for all your work. And again, Heather, thank you for setting all this up and keeping us on track.
Thank you so much.
Thank you.
Have a nice
See you all.
afternoon.
Great
Bye.
night. Good
Have a
evening.
good day.